while they do that. Ma'am, what's your name in the back? You have a case here today? All right, I just wanted to just say thank you because you could have sat there and not done anything, but you're getting up and helping that gentleman get himself out the door. I do appreciate it and it was noticed. Your name, sir?
Oh, Donald Wood said,
Thank you.
can I say something? I'm sorry, I'm just,
No, if you want, but you have an attorney there to speak for you. I don't know.
okay, but I know, I'm saying I do.
Why don't I speak first? We've been working on a resolution, and that is for a misdemeanor. There were some charges that were coming up potentially out of 14B, and with that, we were working to try and still resolve it.
All right, guys, buckle up, because this courtroom moment opens in an unexpectedly human way. Before anything legal even begins, the judge pauses to acknowledge a quiet act of kindness in the courtroom. It immediately sets the tone. This isn't just about charges and procedures, it's about people being seen. That brief interaction draws everyone in, lowering defenses before the legal tension quietly starts to build beneath the surface.
I understand that there's a new potential charge that occurred about 3 weeks ago while Mr. Whitsett was in custody that's being reviewed by the prosecutor's office. They've asked for a short adjournment to review that report to see whether or not they're going to authorize charges. There may still be an offer of a misdemeanor on the table. The prosecutor's asking for 2 weeks to be able to come
To look at the whole picture.
Had at that time.
You know, it would be a joint request.
right.
I'm not
Yep, yeah,
specifically asking for, because if that's a new felony, will it revoke the misdemeanor offer that had previously been contemplated? Probably yes. If it gets denied, then we can resume.
Things turn serious fast here. Defense counsel explains that a misdemeanor resolution was close, but now a new incident, allegedly happening while the defendant was already in custody, has thrown everything into question. Suddenly, a clean exit feels uncertain. The word felony hangs in the air, and you can feel the room recalibrate as everyone realizes this case may be heading in a very different direction.
Course that we were heading towards, but I can't ignore the fact that apparently he's been engaged in criminal activity the last few weeks.
Can I say something?
Okay, but sir, I want to make sure that you don't say anything about what they're looking at or anything about any charges. Okay, I don't want you to say anything that may hurt you.
So should you say something about the charge?
You shouldn't be talking about the charge.
Okay, Judge Simpson. They said, okay, I'm talking about the other one. Okay, like when they said the first one about this larceny, it ain't came up, and they've been done 8 weeks. I got a newborn baby.
Hold on.
Easter.
What, the larceny?
Yeah, what they said. It was one popped up. It wasn't one because and they said they was kept adjourned for it. Now it's talking about this other case, and it's nothing. I don't even see why he had a paper he came to show me yesterday. It was a job count 1, and I plead to usage for the judge.
Right, but did you listen to what was just said?
This is where tension spikes. The defendant tries to speak, but the judge steps in firmly, warning him not to say a word that could hurt his case. You can hear confusion and frustration in his voice as he references other charges and delays. It's a raw moment, someone desperate to explain, colliding head-on with the reality that silence may be his only protection.
There's some activity, I don't know what it is, and I don't want to hear even your version of it, but there's some activity that occurred, that may be criminal activity that occurred while you were in custody. That's been sent to the prosecutor's office to review to see if there will be additional charges. You follow that?
Yeah.
They're making that decision, okay, about whether or not new charges will come. What I guess you're explaining to me about the plea offer and what Mr. Drukas would have explained to you was indeed the plea offer, but now this other criminal activity may change the prosecutor's position as to whether or not you could do that. So what your counsel is jointly requesting with the prosecutor's office, and I think it's a smart thing to do, but you might disagree, is to adjourn it out a couple weeks, figure out what they're going to do. If they authorize charges, that misdemeanor plea may not be in play anymore. If they deny it, then the misdemeanor plea and what you talked about, you can go ahead with.
Okay, but I've been here 8 weeks. I got all these kids with her, and then she had another baby on Easter, and I'm just been in here. And
The judge breaks everything down in plain terms. A new alleged criminal act is under review, and depending on what prosecutors decide, the earlier plea deal could vanish entirely. The court agrees that waiting is the smartest move, even if it feels unbearable for the defendant. This is the crossroads moment. Everything hinges on a decision that hasn't even been made yet.
I got my parole. I was talking to my parole the other day. She even took up the charge. Like I don't know. I don't see how I'm still in here. He's talking about a felony. There's no felony got to pop up.
Well, I don't know that.
Because if I get assaulted and
Well, I don't want you,
okay.
okay? I mean, I don't want you saying anything about a case that may be coming up against you, because that can be held against you, okay? That's the reason I don't want you to say. All right.
All right.
I would ask for 2 weeks for a new. You want to address?
Probable cause conference, May 30th. Is that right?
Yes.
2024, 9 a.m. Bond continue.
Your Honor, he wants me to address bond. I know we
Go
addressed
ahead.
bond here last time. If the court would allow him out, would go to community corrections and test. I think the last time that we addressed bond, it was the fact that he didn't show up last year.
Correct.
He has been in custody for a period of time. He has sobered up. And asking to be able to test a community correction.
And I let him out. He doesn't show, he was gone
And
for all that
he
time.
would not object to a GPS tethering.
Not doing that. I denied it previously. I don't see anything that's changed. Motion for bond reductions denied.
Thank you.
Judge,
What?
good afternoon, Robert J. Cole on behalf of Wardell
What
Smith.
did he say?
Judge,
No, no,
what?
can't come up here.
That's fine.
You're looking to cut, I know what you're trying to do because you're starting to walk there.
Emotions spill out here. The defendant talks about time spent in custody, his children, and a newborn baby, clearly overwhelmed. Then comes the bond request, and the judge shuts it down. Past failures to appear outweigh recent sobriety claims. It's a tough reminder that the court doesn't just hear promises. It weighs patterns, history, and credibility above all else.
Judge, Judge, I called Wardell. He's stuck in traffic, but he promises 10 minutes. Can you please pass? You are the most considerate, gracious judge. I know, so I'm sure you won't object.
Wardell lady in traffic.
Thank you, Judge.
From where?
Well, he just said he's 10.
From Ipsy?
Judge, have you gone down Washington Avenue lately?
Yes.
Oh, you come here early because you're such the judge type, he gets here early all the time.
The judge type? I don't know what that, fine, kill all, I'll pass it. You worn me down. He wasn't leaving the podium till he got that. Uh-oh.
Good afternoon, Your Honor. Nancy Berger, requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of the most punctual attorney, Jay Ballinger, representing Mr. Pate, who is present.
Wow. I almost want to deny it because that's not true.
The mood shifts dramatically. What was heavy suddenly turns light as attorneys joke, traffic excuses fly, and the judge's personality takes center stage. The courtroom relaxes for a moment, revealing the human side of legal proceedings. These brief exchanges matter. They reset the room and remind everyone that even serious systems are run by real people.
Where are you from, young lady?
I'm originally from California, but I'm attending law school at Michigan State.
Where?
Michigan State, go green.
Brown, you need to talk to her. Come in here, spell terrapin really fast. You can't do it. You're
They
a
didn't teach us that
Spartan.
yet.
You're a Spartan. Anything longer than 7 letters, you can't get. All right. I guess permission to practice is granted.
Thank you. Please state your name for the record.
Robert Pate.
Thank you.
We are seeking adjournment for 2 weeks out to discuss the potential for,
Is that written all down there?
it is,
Okay, go ahead.
okay, for, for a global resolution.
Your Honor, no objection, and on the record, we had a discussion before we got here. She was very worried that I wouldn't be kind to her. We had no
What?
idea.
What? Oh, that you wouldn't be kind to her? I was kind. Hey, Emily, was I kind? Okay. Glad you all jumped on my bandwagon. Probable cause conference, May 30th, 2024, 9 a.m. And we'll continue. Thank you. Thank you, sir.
Thank you, Your Honor.
Michigan State. I didn't even know they had a law school. Brown, I don't know how you let anybody get up here and say go green anything. No. We'll talk. I'll send you an email.
The case wraps with a mix of humor and formality. A law student gets permission to practice, school rivalries spark playful banter, and the adjournment is officially set. With the next court date locked in, uncertainty remains, but for now, the gavel moves on. If you found this breakdown helpful, make sure to like the video, subscribe to the channel, and we'll see you in the next video.